Greetings and welcome to today's webinar, Development in Non-Compete Law and What to Expect Ahead. My name is Eric Johnson. I'm a partner with Quarles & Brady in the Labor and Employment Group in Phoenix, Arizona, and I'm here today with my colleague and co-presenter, Nicole Simmons.
Good morning, everyone, and possibly good afternoon wherever you're located. Just to briefly talk about our backgrounds, we obviously are lawyers. Employment lawyers. We handle litigation mostly on behalf of employers in various industries, including tribal governments, and we obviously handle claims dealing with Title VII, ADA, FMLA, and any other acronym you can think of probably out there. So I just wanted to give you that brief background very quickly. Before we begin the presentation, we do have a few housekeeping items that we wanted to go over. First of all, we are in listen-only mode. That means that we have muted all phone lines for those dialing in and for participants listening in audio via computer. So you will not be able to speak. That just helps limit the amount of background noise that we're getting. Second of all, if any webinar participants have a question, please feel free to type your question in the chat box located in the upper right corner of the webinar dashboard and then hit submit. That will help us see the questions come in throughout the presentation. And feel free to enter those questions whenever they come to mind. Third, we would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. And finally, we will be applying for 1 hour of CLE credit. If you are an attorney and would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the materials found in the handouts panel of the webinar dashboard. Please complete the form and return it to the contact listed at the bottom of the document. There is also an HR attendance certification form in the dashboard materials for human resource professionals to use in self-reporting. With that being said, let's go ahead and get started. All right. So let's start with a brief agenda, just so we know where we're going today. We're going to start with a very brief overview of restrictive covenants, just so we make sure everybody has a baseline understanding of what restrictive covenants are out there and what each does. And then we'll spend the bulk of our time talking about drafting considerations, because most of the individuals on the line are employers, and they want to figure out how in the world do we draft these types of restrictive covenants so that they're enforceable in a court if they get there. And then finally, we'll end with a look ahead. We want to look at some of the trends in the law that are happening now and where those trends are going to take us in the future. So let's first look at the types of restrictive covenants. There's the most common one, which is a confidentiality agreement. Many of you have seen these, signed them, given them to employees. They're very common out there, just requesting employees to honor the confidentiality of certain documents. Then we have a non-solicitation agreement, which is a very typical agreement that asks a former employee to please do not steal an employer's employees after they leave the employment. And then we have hands-off anti-piracy agreements, which is typically when a couple employers get together and agree to not steal each other's employees. And then we have non-compete agreements. Obviously, those are asking a former employee to not compete with the business after they leave employment. And then finally, the common law and statutory protections. The one that comes most frequently to mind is trade secret acts that have been enacted in states across the country. And we can talk a little bit more about that later. So what are some of the common drafting problems that we see, and not only for employers, but for lawyers alike, because we obviously have a practice across the country, though it's mostly focused in Arizona. And so we also have to know what the jurisdiction is that we're dealing with, because if you do not know your jurisdiction, the law can change widely between states and also from judge to judge. So let's talk about the spectrum of legal attitudes that we'll see across the country. Typically, restrictive covenants are viewed with disfavor, and the general idea is to limit the broad strokes of these agreements to only what is necessary. The caveat is most states do treat anti-solicitation clauses under a looser standard than non-compete. So this general disfavorment is more geared towards non-competition, and the reason being is because that is limiting commerce, and courts typically do not want to limit commerce and employees' free will to change employment. So how do courts deal with this disfavorment? How do they implement this disfavorment? It's usually through the blue pencil approach. And that blue pencil approach is a common law doctrine permitting a court to delete overbroad restraints while enforcing the remainder portions of the contract so long as it does not offend the central purpose of the agreement. Of course, because non-competes are treated differently across the country, you also have different shades of blue and how the courts are enforcing this blue pencil rule. So you have two large buckets. One is the strict blue pencil rule, which primarily allows a court to strike out provisions in a non-compete, but it will not allow the court to actually modify the agreement or add in or write in terms of the agreement. States like that, as you can see, obviously Arizona is one of them, Idaho, Indiana, Illinois, North Carolina, they follow the strict blue pencil rule. The liberal blue pencil rule is a slight take on the blue pencil rule. It essentially allows a court to modify an agreement so long as it comports with the party's intent. And as you can see, that is the majority of the states in our country. They follow a blue pencil rule. Now, of course, there's always some oddball jurisdictions out there. Most of you are probably aware California generally takes a void as a matter of public policy approach when it comes to non-competes in the employment context. Oklahoma has a similar approach as California. However, it will allow modification of an anti-solicitation clause. Remember, we said earlier that anti-solicitation clauses are typically treated under a looser standard. This is one of the states that does that. The Wisconsin approach indicates that it's entirely void by statute if unreasonable. So it's not like California where it says it's entirely void. Instead, it says it's entirely void if unreasonable, and it will allow, or it will not allow any blue penciling. So you better come out the gate with a reasonable non-compete. Virginia, Arkansas, and Nebraska follow a similar approach as Wisconsin. But note that one federal court in Virginia has allowed some modification within a restrictive covenant.
Yeah, Nicole, quick point. For some of the liberal blue pencil jurisdictions, I believe, even though they have the authority to blue pencil the agreement and make the provisions enforceable, that's not a mandatory requirement. There's certainly numerous cases in those states where that's where the court has the authority to do that, where the court will refuse to exercise its jurisdiction, particularly if it's, extremely, long duration or geographic scope, overbroad. A court might say, this is just so overbroad, we're not going to blue pencil it. It's unenforceable as a matter of law.
Absolutely, absolutely. There's definitely some confines in there with the liberal approach. So finally, we have some unsettled jurisdictions out there: South Carolina, DC, Maryland, New Mexico, and Rhode Island. Generally, there's just no law stating clearly whether they're going to follow the blue pencil rule one way or another. So even if it's not enforceable, even if a non-compete or restrictive covenant is not enforceable, we do note that many employees will voluntarily comply with a restrictive covenant to avoid the risk and cost of litigation, especially if there's a risk of having to pay the other side's attorney's fees or the employer's attorney's fees. And this is the interim effect. There's an Arizona case out there that talks about this effect, which has actually given rise to the strict blue pencil rule or the reasoning underlying it. However, it's not effective, and this goes to Eric's point earlier. This idea is not effective where the restrictions are so overly broad, it causes the employee to question whether it's enforceable, especially with all the information out there now these days with non-competes. So I pass it to you, Eric.
All right, thank you, Nicole. So in terms of drafting non-competes, obviously the goal is to draft the non-competes in a manner where they're going to be upheld to the extent there's litigation later on and you're trying to enforce the restrictive covenants against a former employee. So the question here is, think about how much protection you can get away with versus how much protection you need. Well, the difference in between those two could mean the difference in enforcing a non-compete versus having a non-compete held unenforceable. There's essentially two key questions for you to think about when you're in a litigation, and that's one, does the employer have a business interest that the law views as sufficiently strong to justify imposing the hardship of a non-compete on the ex-employee? And two, Are the restrictions in the clause in terms of length, territory, and activities necessary to protect the employer's legitimate business interest? Now, if the answer to either of those questions is no, then the agreement is probably going to be held unenforceable in most jurisdictions. With respect to the latter point, or question 2, the reasonableness or the ability to enforce the restrictions, there's various factors courts look at when determining reasonableness. One is, what is the protectable interest that the employer is trying to protect by using a restrictive covenant? Is it customer relationships? And we'll discuss some of the different protectable interests in a moment, but is that based on customer relationships or the protection of confidential information or some other reason? Duration. A court's going to look at the temporal scope. If you have a 1-year non-compete, is that reasonable, under the circumstances of that particular case and for that particular employee to have a 1-year non-compete or 1-year non-solicit? The geographic scope. What geographic area does the non-compete cover? This is an easy overreach sometimes for employers. When they want the most protection as possible, so they maybe go a little farther geographic-wise, then probably, they have a legitimate, or probably that, higher than what they have or larger than what they have a legitimate protectable interest, in protecting through the non-compete. So, for instance, if you've got a sales agent or a sales rep and they're assigned, a particular county in your state, that seems like that would be a natural geographic scope for the non-compete, the assigned territory for the sales rep. To the extent you nevertheless put in the whole state, but they only deal with customers in a particular county, in most jurisdictions, that's probably going to be held overbroad. And in some cases, that'll mean the non-compete in total will not be enforced. In others, you may have a court blue pencil that and reduce it down to a county, but that's a risk you're taking by going overbroad. So even if you're in one of those liberal jurisdictions, as Nicole and I have mentioned, you still want to tailor your non-compete and your non-solicit, to the particular facts of your case and make sure they're reasonable. And you don't want to rely on the blue pencil rule by any means. In terms of hardship, that's a judge is always going to look at the hardship to the parties. What's going to happen if I enforce this agreement? Now, in 90% of those cases, obviously the hardship is going to, likely fall on the employee or ex-employee more than the company or employer, just due to financial considerations, obviously. And, the employee is potentially arguing, well, hey, this is affecting my livelihood. I need to support my family, put food on the table. So clearly I'm going to have much more of a hardship than the company that has, unlimited funds potentially, who's trying to enforce this agreement. Now, in terms of the public interest, that's, one more factor that a court is going to look at when determining whether or not to enforce a restrictive covenant. And that, frankly, kind of goes both ways. I mean, you certainly have an argument that it's in the public interest to be able to enforce, written agreements that were voluntarily entered into by two parties. That's something that I'm sure any state generally has a public interest in following. Flip side is, well, we don't want to enforce contracts that contain unreasonable terms and unnecessarily provide, an unlawful restraint of trade or an overbroad restraint. So those are kind of the general, factors a judge will look at in determining reasonableness. And those are the factors that you need to think about when you're drafting the non-compete, because those are the factors that are going to be challenged later on. In terms of, the business interests legally recognized, these are the interests that you're trying to protect by having a restrictive covenant. The first item we have listed here is technical know-how. This is, what does the employee do? How skilled are they? This could go, and we're not talking about, their duties are top secret or anything like that, but certainly the higher the skill level of the employee, potentially the longer you're going to be able to have your non-compete run. Also, maybe it's not necessarily a highly skilled position, but for the company, there's a lot that employee must learn in terms of training, how the system works. So for them to be able to get up to speed in their particular position, you want to have a non-compete that gives you some time to train the new employee and to get them at least being able to perform, more or less the essential functions of the position. Another business interest, business interest that is used to justify non-competes or non-solicits. Well, and these actually are two. They go hand in hand, trade secrets and confidential information. Obviously, you've got a protectable interest in trying to protect your trade secrets. Now, I will say this, in terms of the agreement, the restrictive covenant agreement that you may have, you can include references to trade secrets there that, it includes, the prohibitions on the disclosure or misappropriation of trade secrets and confidential information. But you should know that, even if you don't address trade secrets in the agreement, there's still most likely in your state Uniform Trade Secrets Act, which would probably preempt, any contractual provisions anyway concerning trade secrets. And there's also, the new federal law, or relatively new, the Defend Trade Secrets Act. So that's going to be available as well. But in your agreement, and Nicole mentioned, when we were talking about these types of agreements, you could have a separate confidentiality agreement, a separate non-compete agreement. Typically you probably just want to include all those things into one agreement, if you can, and if it makes sense. There might be some reasons why you want to split them apart, but generally you are able to include all of those different types of restrictions in one particular agreement. Now, the confidential information protection, you could have a confidentiality agreement or provision that contains kind of the boilerplate language, but, is that really, protecting what you're looking, specifically what you're concerned about? For instance, if there's anything in particular to your business, maybe it's the pricing structure, maybe it's some sort of other, other confidential information that you're really concerned with, and that keeps you up at night when an employee leaves because you're concerned, are they going to use and disclose that info? If there is something like that I would specifically mention that in the confidential information section of your agreement. So there's no dispute. You can't claim later on, which is always the case in these types of litigation matters when there's confidentiality issues. The person, the ex-employee is going to argue, oh no, that information's not confidential. They didn't keep it confidential. They never told me it was confidential. One thing you can at least try to do to undercut that is say, no, look, we specifically mentioned that particular information, and you agreed that it was confidential. It's not necessarily dispositive, but that's something that you definitely want to consider doing. In terms of some other protectable interests, customer relationships, of course, those are going to be something that an employer, seeks to protect through the use of a non-compete or a non-solicit. And goodwill, you've got, in a lot of situations, let's say you have a sales agent or sales rep. For various customers, they might be the face of the company to that particular customer. That customer might not interact with many others in the company other than, that sales agent or sales rep that leaves. So when they leave, it's not easy to replace them immediately, especially in the customer's eyes. So by having a restrictive covenant that gives you some time to kind of continue that goodwill or to generate new goodwill with that customer in order to fill the void that's left by the ex-employee, that's certainly a basis for a non-compete or a non-solicit. Other business interests, well, we've got detailed customer information, which that, certainly falls under the ambit as well of confidential information, most likely. But a couple things I guess I want to point out. Well, first, what's not mentioned there are customer lists. Is a customer list confidential or a trade secret? Well, it depends on, the law in your state, and it depends on the circumstances. There's some industries where, in terms of the customers for your industry, you can find out who they are by opening up a phone book, and you can list off all your customers or potential customers. In other industries, it's not so clear cut. You don't necessarily know who the customers are. So, just the mere fact that someone takes a customer list, that may or may not, be a confidential or trade secret document. In fact, it may be deemed as, not confidential and not a breach of the agreement. However, the names of key contacts, that, in a lot of situations is probably more valuable than the customer list. Because it's one thing to cold call a customer and, try to get to someone who can, who's to find the appropriate person to talk to. But if you already know who that person is and what their phone number is, you can cut out, a lot of the work, the legwork needed to get to the person who can make some decisions. So, that's something that, yeah, many companies want to protect. Other types of confidential customer information that you can use to try to justify a non-compete, ordering history, customer preferences and idiosyncrasies. As we'll discuss throughout here, one of the goals of having a non-compete is to give, the employer, the company, the time to recruit, find somebody new who's qualified for the position, and then to train them and get them working. Now, you don't necessarily need to get them to the level of where the prior employee was. Maybe the prior employee was with the company for 20 years, and you're not going to, replace that person to the full extent or at the level that that person was at, within a year, maybe even or so, or longer. But once you have someone trained, they're in the position, they're meeting with the customer, and they're at least able to perform the general functions of their position. I mean, that's going to, be an argument that you can use to help justify the non-compete. High-level strategic information. I mean, obviously that could be extremely valuable to a company, and you obviously do not want that type of information disclosed to your competitors, or to certainly be used against you by competitors. But what about some business interests that are not recognized? I mean, obviously, got many clients who would love to say, well, I want to non-compete because I don't want this person to compete against me when they leave. They're a skilled employee, they're great with customers. I'm going to lose business if they compete as soon as they leave. Well, most states, in fact, probably every state, is not going to allow competition, or to prevent competition just for, the sole purpose of preventing competition. You need to link it with that, legitimate protectable interest that we were talking about. What about like recouping training costs, protecting an easily duplicated customer list? Training costs, that's going to be insufficient. There's other means you could do to potentially address that point, depending upon your jurisdiction. But protecting an easily duplicated customer list, like I mentioned before, is that really, a trade secret or confidential info? There's a good case in Arizona that's often cited, and it says when an employee leaves, one company to go to work for a competitor, it doesn't mean that employee has to undergo a prefrontal lobotomy. They can't forget everything they learned. They're not going to forget who the customers were that they worked with. So, the mere fact that they might have that knowledge, you've got other protections to prevent them from using confidential information, and you also, of course, have the non-solicits and non-competes, but that's what those restrictions are for. The mere fact that, an employee has certain types of knowledge, including a customer list, might be insufficient to support your agreement. Okay, considerations in selecting a duration for a non-compete. Obviously, there's no one answer, and there's certainly no one answer, nationwide, and there's not even one answer, in 99% of the states at issue. Most states hold that, in setting the duration or temporal scope, that's going to depend upon the specific circumstances, of that particular case and the particular job at issue, the interest that's being protected. Let's see, we have here, when protecting customer relationships, consider the length of time necessary to rebuild the relationship. If you have, let's say you have a sales agent who works closely with customers, and this is a relationship where you have a product where that sales agent works closely with the customer a lot. Every time, a product is, purchased, the rep has to go to the customer, teach them how to use it, maybe train some other employees, answer various questions about the product, various other things. That's more involved than, say, another sales rep where, you don't need any training. They're almost like a go-between, just, in delivering goods and maybe getting the payments or delivering the invoices. For, the former, you might have a substantial period of time to be able to replace that person, and maybe that's going to be 6 months, maybe it's going to be a year, to try to, build the goodwill back with those customers based upon that employee leaving. But in the latter case, if you've got an employee that, they're really, like I said, just kind of a middleman, and you can find and replace someone to do that job and train them, within a week, then having a 6-month non-compete is probably going to be overbroad. Okay, so that when replacing employee, consider time and time to rehire and get employee up to speed. Okay, we kind of just addressed that. When protecting trade secrets or confidential information, consider the amount of time it would take to replicate it and how long information remains valuable. Well, that's a good point. With respect to the latter point, let's say the pricing information that you have is, it changes every year. It's extremely confidential. You don't disclose it. And maybe you even have agreements, confidentiality agreements with the customers that they're not going to disclose it. You only change the pricing, or you change it once a year. In that instance, and there's certainly various cases that would support this, well, it makes sense. Okay, yeah, you have a 1-year non-compete because that confidential information is only going to be valid for 1 year. So that makes sense. Now, it could go on, let's say you switch your price to that same type of confidential pricing every 6 months, but you have a year non-compete. Well, you're not going to be able to enforce the non-compete if you're focused solely on, the pricing info. You're going to have some other justification to justify, the longer, 1-year period instead of 6 months. Towards the end here, we've got also note some states require a temporal limit to be included in confidentiality clauses. Wisconsin follows this rule. I can tell you Arizona does not. A point about confidentiality agreements. So, well, first, obviously, if your jurisdiction does require a temporal scope to be placed in your confidentiality agreements, then, yeah, you want to do that same type of analysis that we just discussed. What type of confidential information are we talking about, and how long really is it confidential? But I do want to mention, to the extent you have a confidentiality agreement or you have a pretty strong confidentiality provision in your restrictive covenant agreement, there are some cases, and this includes Arizona, where courts are really cracking down on overbroad confidentiality provisions. For instance, if you have a confidentiality provision that says basically everything that you learn or that you come into contact with, during your employment concerning the company is confidential. In a lot of states, that's going to be far too overbroad. Like I said before, in Arizona and various other states, you can't have an employee forget everything, that they've learned. And, what the problem is, if that's overbroad, what some courts will do, and I've seen cases take this position, well, essentially, you're saying everything this person learned during their entire employment is confidential and they can't use that. So if they can't use that, then basically they can't compete against you. So now I'm going to treat that like a non-compete agreement. And now I'm going to look, is this reasonable as a non-compete? Oh, no, there's no geographic, restriction on this confidentiality agreement. So, I'm striking the whole thing. So point is, I'd be careful with the confidentiality agreements. You need to make sure you're only covering information that's truly confidential and information that's not available to the public. Sometimes I see agreements where it says, confidential information is X, Y, and Z, and includes information that's not readily available to the public. Maybe you can get bits and pieces out there in the public, but you would have to put that together. It would take a lot of time and energy. Some courts are going to say, well, I don't care if it's hard to do, or even if it takes a long time to do it. If it's publicly available, it's not confidential. So, okay, so I just wanted to mention that tolling provisions, that's a very important provision that oftentimes I have clients present me with some agreements that they had previously been using that did not have a tolling provision. The tolling provision essentially says, if you're violating, the terms of this agreement, the non-compete agreement, for instance, let's say you have a 6-month duration. If you're violating the non-compete, the 6-month period is not going to run until you're complying with the non-compete. So if they leave your employment, they're competing with you the next day. Let's say you don't find out for whatever reason, it takes you 4 months to find out that, oh, geez, okay, they're violating the non-compete and we're losing business related to that. You run into court, get a TRO or preliminary injunction. You're already 4 months in. If there's no tolling provision, a judge might say, okay, well, yeah, I think you've got meritorious claims. I'm going to order the injunction up until the 6 months, but that's only, in 2 months at this point. If you have a tolling provision, this isn't going to for sure ensure that you're able to do this, but at least it gives you the opportunity to argue to a judge. Well, judge, look, we have a tolling provision. We've never got for the last 4 months, we haven't gotten the protections of the non-compete that this person agreed to. So one, yes, we want to pursue damages for what they've done for the prior 4 months, but we also want, the benefit of what the parties contracted to do, and that is for the employee to not compete per the terms of the agreement for 6 months. So starting whenever the court orders, the injunction, that should be when the 6-month period starts. So you definitely want to include those provisions in your restrictive covenants. All right, some other considerations in selecting a duration. Approaches vary by state law. There might be some cases where you could enforce a 2-year non-compete quite easily or in your jurisdiction, but there's other states that, even statutorily, some states don't allow you to do that. They set a maximum in terms of how far, what the largest temporal scope may be. Now, I say here, Arizona and Wisconsin, 2 years is generally considered maximum. For Arizona, yeah, that is on the long side. I mean, that might be the maximum, but that's not the norm. In most situations in Arizona, you're not going to be able to enforce a 2-year non-compete. Unfortunately, we can't give any guidelines onto what generally an enforceable time or temporal scope would be, because it does depend, as we've discussed earlier, upon the specific position we're talking about and the employees at issue. All right, tip, when including a temporal limit and confidentiality clause, either in those states where you have to, or you could do it if you, for whatever reason, you think that's an appropriate thing to do with your confidentiality agreement or provision, expressly state that the that the contractual protection is intended to be in addition to and in not lieu of protection under governing trade secrets. Like I said earlier, you've got the Trade Secret Acts, and protections of those statutes. You don't want to, try to contractually limit your ability to utilize those, assuming they're not, preempted. But you also don't want to say, okay, our confidentiality provision, it's subject for 2 years, but maybe the trade secret law allows or provides that you can pursue trade secrets up to a period long after an employee has left or obtained or misappropriated the trade secret. So you just want to distinguish between the two. You don't want to limit your remedies. You want to be able to pursue both contractual and statutory or common law causes of action with respect to confidential information. And in regard to some common law claims, in a lot of jurisdictions, the misappropriation of confidential information, you're going to be able to pursue claims related to that under various tort theories. Maybe your state has a broad unfair competition law. An employee in most states is going to have a duty of loyalty or a fiduciary duty owed to the employer. That duty, obviously, generally when they're working, they've got a duty not to compete against you or to use your confidential information against you. But in regard to confidential information, that duty extends even when that employee leaves. So, whether you have a confidentiality agreement or not, you still have an argument that, well, hey, this employee continues to owe us a duty of loyalty. They learned our confidential information. And even though there's no agreement, confidentiality agreement, they've got a common law duty to not disclose or use that information. Okay, territory restrictions. So this is the geographic scope of the non-compete. And like I mentioned earlier, this is an area where a lot of employers overreach. Generally, where an employee principally works is the appropriate area or geographic scope for non-compete. Like I said before, if their sales territory is, Maricopa County, then that should be what the restriction on the non-compete likely is. And I keep referencing sales reps and sales agents. I mean, those, oftentimes those are where these cases arise. But of course, we can have non-competes for various other positions. But for the sake of our discussion today, I'm just going to be focusing a lot on the sales agency relationship. But so here I've got, for salespersons, geographic territory versus active account list. Now, active account list, that kind of goes, that brings us more kind of towards the non-solicitation of customers provisions or agreements. When you're thinking about implementing a non-compete or a non-solicit agreement, you need to think about, what are you really looking to protect? I mean, do you care if this person is really going to be competing against you in the county, with somebody else, if they're not going after, your customers that they had contacted with or that they'd worked with, during their employment with you? I know a lot of times, I get a client's call and they say, Eric, I've got this person in Colorado, and he or she, they work at a tiny little office there, or maybe they work remotely, but, they deal with our customers literally in, every single state in the country. So, we want to non-compete. We want to have that nationwide because they can hurt us just as much in Alaska as they can in Colorado. So, we need to prevent them from going after our old customers. A judge, and in that case, I think I would say, well, is really the non-compete what we're looking to here do, or, is that what we want to do? We want to prevent them from competing, period, or is it sounds like the big concern is the solicitation of the customers. And if that's the case, do you even want a non-compete? Sometimes you might have a non-compete. You could certainly make those arguments for your non-compete that the person, deals with customers all over the country. But is a judge really going to order, an individual not to compete in the entire country? So they're either going to have to change, at least professions maybe, or industries, or they're going to have to move to a different country. I think a judge would probably take the position, no, I agree you have a protectable interest in your customers, so you could have protected that by a non-solicit. By having a non-compete that's, overbroad and unenforceable, and I'm not going to do that. So just things to consider. And also, I guess let me just get into a little discussion about, non-solicitation of customers. You also want to, depending upon your jurisdiction, it varies how detailed you need to be and what carve-outs you need to put in there. But, what is the company's protectable interest in its customers? One, who are you trying to protect? Your current customers. So let's say, you might have a non-compete or a non-solicit agreement right now that says you cannot, or employee cannot compete, or cannot solicit any customer of the company for 2 years. Now that, that one simple sentence, that's a very broad, and it can be, or will be dissected and challenged on various grounds. Let's talk about the first thing. We just said customers. We didn't say current customers or active customers. We just said customers. So a natural question is, well, what do we consider a customer? What if it was someone who you haven't done business with, in 3 years? What if it was someone you haven't done business with in a year? Is that person still considered a customer? Also, what if you have a situation, excuse me, what if you have a situation where, let's see, if you've had a customer who says, for whatever reason, let's say this is like a month before the employee goes, the customer contacts you and says, we've decided to go with another company. We think they're cheaper, or for whatever reason, we're just going to go with them. So, thank you for your service over the years, but we're no longer going to need your services. That person may have just bought some products from you a month ago. Now, if I read that non-solicit provision that says you can't go after the customers, I'm sure there's a good, decent argument that, well, hey, this person, they bought a product from us a month ago. Of course, we consider them customers, and this person soliciting them is a violation of the agreement. A judge, depending upon where you're at, certainly would take the position that, what protectable interest do you have in a former customer? If that customer is not going to do business with you, why on earth do you care if that employee who just left is going to be soliciting someone who you're not going to be doing business anyway? I suppose you could argue that, well, hey, we're trying to get that customer back, and we need, we don't want to be interfered with while we're doing that, so we want to enforce a non-compete and at least give us a chance to get that customer back. You can make that argument, I don't think it's probably going to be successful, but you can make it. So, typically I can tell you what I do for non-solicitation provisions. one, I want to give a time frame for the customers at issue. Well, first, I want to say current customer. Now, there's always going to be a dispute if someone leaves your company, and says, I don't want to be a customer anymore. Did they make that decision, on their own, or did they, say, ooh, I want to do business with the guy who's leaving, so I'm going to end my employment relationship because I've talked to him, and then I'll say I'm going to call him and do business. Now, it's the kind of the chicken before the egg issue. That's always going to be an issue. But so what? But it is what it is. I mean, you're going to have to litigate that potentially. But so I would limit it to current customers. I would also say, and when we say current customers, those are those customers that we still consider customers, who we've done business with. And let's say if we're doing a year-long restriction, I'd say, that we've done business with in the past year. Now, what about the restriction applying to all customers? This particular employee might have only worked with a handful of those employees. What's the protectable interest in preventing that employee from, working with these other or soliciting these other companies that they might not even know existed, at the time they were at your company? A lot of courts, and depending upon your jurisdiction, might say, yeah, there's no real protectable interest. That person is soliciting them almost on the same level as anybody else would be soliciting them. They don't have prior knowledge. Now, if they had confidential information about those customers, maybe that's a little different scenario. But generally, so what I would do is I would limit, to ensure chances of enforcement, I would limit the solicitation of the customers. One is the current customers of the company you've done business in the last X months. And then it's for the customers that this particular employee has serviced within the last X month, or at least had communications with. Or, we could put in there, has the access to confidential information for those particular employees. So that, that hope there is to wipe out a lot of these arguments that the employer has no real protectable interest. Okay, so getting back to the geographic scope again, territory restrictions, executives and managers, typically broader geographic scope. Just in general, duration and geographic scope are going to be broader for the higher level employees. And I will say in some states, I believe Colorado is one where you can only have a non-compete for like a manager level and above position. If you are having, a lower level, employee, entry-level positions sign non-compete or non-solicit agreements, I mean, that's problematic. Some states have, outlawed that. You're unable to do that. There was a case in Illinois where Jimmy John's sued, one of their employees because there was a non-compete that prevented them from working, at sandwich places, within some sort of, vicinity of their current location. This was employees who were making, just above minimum wage. There was no real protectable interest other than, this was just trying to prevent competition. And then I think Illinois subsequently passed some legislation in terms of the employees that you can subject and employees you cannot subject to non-competes. Okay, Nicole, do you want to take this?
Sure. And before we move on, since you were dealing with kind of the geographic scope, we did have a question that kind of fits nicely in that area. So, Eric, what would you think about, what would you typically say about an online business? How would you deal with the geographic scope dealing with that?
Yeah, no, great question. And that's, when I mentioned, I've had clients come to me and say, I've got an employee in X state, but, we do online stuff. We got not only customers in every U.S. state, we've got customers, in various countries across the world. This person can harm me from any place. Like I said, in that situation, the non-solicitation of customers is going to be, frankly, the more valuable thing than the non-compete. You could still have a non-compete. And sometimes I tell them too, so our main goal to protect those customers is to have the our main effort in order to do that is to have the non-solicitation of customers. Instead of doing a nationwide non-compete, however, or worldwide, whatever, what about, in that particular region where they're at? So at least make it, If they're, in Denver, Colorado, maybe we still have a non-compete that says, you can't compete with us within the city of Denver. Then we're kind of covering, they can still go outside of Denver and, potentially damage you just as much as from any other location. But, at least, they at least have to do something more than just abide by the anti-solicitation provision. So that's at least an option that you could consider in that type of situation.
Okay. So it has to actually be tied back to the locations where the employee actually had some impact or work.
Yeah, I have, and I think we'll mention at some point, I have had this situation, and this was in the sale of a business context, which is generally easier to enforce non-competes and non-solicits in that instance. But, we had a case where, purchase of a business, and the business literally did business in every country, I think, except for Iran and North Korea. And we were able to get an injunction in federal court from the judge because, this was the owner had contacts in, all these countries. And under those circumstances, we were able to do it to establish protectable interest and enforce the restrictions. But in most cases, a nationwide non-compete or things that are that broad, it's going to be extremely difficult to enforce.
Okay, thank you. So we've talked about this balancing act of working through balancing undue hardship against the business interest, and then also making sure you're balancing your non-competes and restrictive covenants, making sure that they are reasonable through a geographic scope and duration, et cetera. So now we're going to talk about activities restrictions. So you need to limit the restrictions that you're putting on your former employee to some kind of legitimate business interest, as we've mentioned before. You really want to avoid overreaching in terms of limiting the employee's activities dealing with any product or any service or any customers covered whatsoever, as Eric has mentioned before. And we call this the janitor effect. So essentially, not all courts have gone to the janitor effect, but it's been called the janitor effect, where essentially the provision in a non-compete is so broad, you are saying the employee can't even be a janitor with a competitor company. We recently had a similar case where a non-compete essentially said that a higher level management person with a swimming company that sold products couldn't even go to a competitor company and clean swimming pools. That's a janitor effect. So you'll really want to focus in the activities that you're restricting, the competition that you're restricting, to likely what the employer or the former employee was actually doing for the company. You might get a little broader than that, but you want to keep it focused in on what the employee was doing for you. And then try and avoid substantially similar language, because again, that gets that too far broad out there. And then you got to define that term at some point. What does substantially similar mean? Any activity that's substantially similar to what the person was doing when they left. That starts getting it outside the confines of reasonableness. So here's a tip. The reasonableness of a covenant is generally judged at the time of enforcement. And why this is important is because you may have non-competes that are over a decade old, who knows, and the employee is still with the company. Once they leave the company, that's when the judge is going to look at whether the non-compete is reasonable and start defining its terms, especially if you're using substantially similar language. So you really want to keep that in mind when you're drafting a non-compete.
Yeah, Nicole, I could say too, when I get a call maybe from a client and they say, this employee left, they're competing against us, we've got a non-compete. I say, okay, great, send me the non-compete, I'll take a look at it. Okay, yeah, they signed it 20 years ago. Well, I don't even have to look at it. I'm pretty sure there's a good portion of that agreement is going to be unenforceable. Right,
especially with the law changing so rapidly. You really want to do a backwards look every once in a while to see if your non-competes are up to date. So no rating clauses, which essentially prevent soliciting or enticing former co-employees to leave. These are generally upheld. This is what we're referring to as anti-solicitation or non-solicitation, which can apply to both employees and also soliciting clients. These are generally upheld, but as we've said before, a lot of states will treat these under a slightly looser standard than non-competes, although the trend seems to be moving towards treating them very similar to non-competes. Like non-competes, they do have reasonable time and other restrictions such as geographic scope, et cetera. So you'll want to keep that in mind. And if you want to be very sure that they're going to be enforceable, you may want to consider just treating them as a non-compete. No piracy or non-piracy clauses. Again, agreements between employers not to hire each other's employees. These are not enforceable in some states. You'll want to be very clear about the law in your state to see whether they're enforceable. I want to point out, and this is very interesting, but 29 states have statutes that prohibit blacklisting, including Arizona, and I put the statute for Arizona up there in case you're curious. But blacklisting essentially is an employer taking some sort of action to prevent a former employee from obtaining future employment. So, these statutes range widely between simply preventing an employee, putting in a bad word for an employee with a co-employer, or going further to make sure that former employee does not get employment. So you want to be very clear about what steps you take in terms of agreeing with your co-employers to prevent an employee from being hired. All right. So another common issue in drafting is consideration. So these restrictive covenants are agreements. They're treated under typical contractual law in most jurisdictions. So you do need the typical offer acceptance consideration stuff. So an offer of a new job is adequate consideration in all jurisdictions, I have to say. A new hire is.
Yeah, I agree. Although for some states I'm aware of, you need to sign the non-compete or the restrictive covenant at the time of hire. Even if you hire someone, they start work and you offer them the non-compete a week later, there's a lot of courts that might say that's insufficient consideration.
Correct, and that's our next point. You want to be very, very clear and explicit that the execution of the non-compete is a condition of hire, and you want to make sure they sign it at the time of hire. Do not wait some time later, because then it gets into our next point as to whether continuation of existing at-will employment is adequate consideration. Then it starts looking more like this is an employee who you are now having hire a non-compete, and in some states that may not be enough. Arizona is still an open question. We found one appellate case from the 1980s that indicated continued employment under very specific facts may be enough for consideration, but there's no cases after that. So it's very unclear whether Arizona would allow continued employment to be valid consideration for a restrictive covenant. Wisconsin recently upheld that it can be, but note that the employment must actually continue for a sufficient period of time. And then you have to put some teeth behind it, meaning you have to fire other employees who refuse to sign the restrictive covenant, showing that you're very serious that this is consideration. Alternatively, if it is post-employment, you can tie the restrictive covenant to some other compensation or consideration, such as a bonus payment, a promotion, there could be a salary increase, and then also newly granted access to confidential information. That would likely be sufficient for consideration. And again, we've already talked about this, failing to advise a candidate that their offer is conditioned upon the execution of a restricted covenant will probably get you in some problems down the road when you try and enforce that restricted covenant. Other drafting considerations, you've probably seen most of these. Drafting concerns when using multiple types of restrictions in the same document. Now, Eric was very right on that a lot of times you'll want a single document with a lot of these restrictive covenants, but I have actually had a case where a court interpreted an anti-solicitation agreement, which was under a looser standard in Arizona, and then treated it under the non-compete standard, which was stricter, simply because they were within the same document. So you have to be very clear when you do go to litigate those agreements that if you are only enforcing the anti-solicitation clause and it's under a looser standard in your jurisdiction, make sure your lawyers only enforce that portion of it so that they can argue that standard applies. Assignment clauses, these happen when businesses buy other businesses with non-competes. Because these contracts, these restrictive covenants are typically viewed as employment contracts, assignment, whether you can assign the contracts varies across jurisdictions. I know, at least in Delaware, you can assign these contracts during the sale of a business because the courts view that as an asset of the business, and the former employer should be able to reap the benefit of that bargain, but it cannot change the obligations on the employee substantially. So there are limitations on assigning these types of contracts. So just be aware of that.
Yeah, Nicole, I would just jump in for a sec too, just to say, I think in general, it's very good to include assignment clause 1, for various reasons. But, I've seen companies before who are looking, who are being potentially bought by another company or looking to buy another company. And one question they may have are, okay, for all these non-compete agreements, is there an assignment clause? I mean, it very well could be unnecessary depending upon your jurisdiction. But you can hopefully at least take that issue out of play by saying, oh yeah, look, we've got assignment clauses, we can put these over to you and you'll be able to enforce them.
Mm-hmm. I'm going to move on because we're running short on time, but these are all clauses that you'll want to consider. Arbitration, there's pros and cons for every instance in which you provide these types of clauses. But deferred bonus compensation is the only one I want to touch on. Just be careful with these, because if you do some sort of deferred compensation for the consideration, make sure it's paid, because otherwise you might not have consideration there. So we just wanted to point that one out. So non-competes in the sale of business and also in connection with stock awards. Note that these typically have a lower standard of enforceability. They're typically, the blue pencil rule will typically apply, but you'll still want to check the law in each jurisdiction. And these are used to structure the, you'll want to structure the deal to maximize your likelihood that the sale of business standards will be used. And that's you.
Okay, thank you, Nicole. Just here. These are relatively self-explanatory, but a few points I just wanted to mention as we're getting close to closing out here. So what do you do when your employee is subject to a non-solicit, non-compete confidentiality agreement leaves? One thing you want to remind that employee as they're out the door, hey, here's a copy of your agreement, just to remind you that you're subject to these obligations and we assume you're not going to violate them. Make sure you ask for all your property back, including electronic information. Do they have stuff at their home computer or on their smartphones that you would like them to either, we can arrange for returning, electronic information or just deleting it. Let's see. One thing that you might also want to do when an employee leaves, certainly if you suspect that they might be, they might have confidential information or they have misappropriated it, is check their email account, assuming, you're good to do that in your jurisdiction. If it's your email account, your server, and they're not have any expectation of privacy in their work email, take a look at that, see their sent items. I mean, I can't tell you how many cases where the employee within the week, prior to them leaving, mailed some extremely sensitive confidential business information to their Gmail account. What about hiring employees subject to a non-compete? Obviously, you want to ask employees at the outset, do you have a non-compete from your prior employer? If so, you want to look at it, maybe get counsel involved to determine, what obligations that employee might be subject to. When you're having that employee sign a new agreement, if you decide to hire that employee, you probably want to include a provision in there that says, a representation that the employee is not going to take or use any confidential information from the prior employer, or depending upon the circumstances, isn't going to violate any, enforceable, non-compete or non-solicit provision. I mean, you'd want to think about that because maybe you're going to hire someone who is subject to a non-compete or non-solicit, but you're pretty sure that it's unenforceable. But just one point here, a lot of clients, say, oh, okay, well, we're going to be good if, that person, turns out did take confidential information and has used it to sell customers, for our benefit, but we didn't know about it. In fact, this guy breached his agreement. He lied to us. He did, use confidential info. That's great. That's an important provision that you want in there, but that's really going to be an issue between you and the employee. In terms of the prior employer, they're not going to care, and they're going to argue, well, I don't care whether you knew or not, or whether, he signed something that said he was not going to do that. The wrongful conduct that he's done was on behalf of you, for your benefit. So you're liable for, any unlawful solicitations. Okay, so just what to expect in the near future. Courts and legislatures will continue to narrow the use of restrictive covenants in 3 ways. 1, treating all restrictive covenants under the strict scrutiny of non-competes. Nicole's mentioned that. Right now, at least in Arizona, you always make the distinction, whether it's in a pleading or in a demand letter, or in response to a demand letter, that there's different scrutiny depending upon what type of restrictive covenant. If it's non-solicit, it's less than a non-compete. Okay, 2, enacting state legislation banning or greatly restricting use of non-competes. I can actually go to we'll go to that in a second. There's states that are increasingly making it more difficult to enforce non-competes and putting statutory limits upon what you can and can't do. Proposing and enacting federal legislation banning non-compete. There are a couple federal bills that have been presented that, would limit the ability of, employers to enforce non-competes nationwide. So you've also got these state issues, and then you also have the federal ones. And specific federal issues are identified at the end of this PowerPoint, as well as some of the difference of the proposed legislation in various states. We're definitely at a time right now where it's getting harder to enforce restrictive covenants, and it's not going to get easier. The trend is going in one direction, not the other. So thank you for your time today. I see our time is up. To the extent you have any questions, it looks like we did get some questions. Unfortunately, we didn't have an opportunity to answer those, but we'd certainly be happy to answer them personally, either Nicole or I. Otherwise, I think, Nicole, do you have anything?
No, we can either, those of you who need to jump off, feel free to jump off. Do you want to stay on for a couple
sure.
minutes?
Yeah, if anyone would like to stay on, we can try to address some of the questions now, but certainly otherwise, if you have other things to do, we've fulfilled our 1 hour of CLE credit.
Thank you, everyone who's about to jump off. And then we'll just go through some of these questions I'm looking at are very specific to someone's business. So we'll probably not address those. We ask that you just email us. Our information will be at the end of this PowerPoint, which I don't think you can see any longer. But you will have an opportunity to get that PowerPoint off of, I believe, is it our website? Yes.
Yeah.
So let's go ahead and just answer a few of these questions. The ones that I noted would be very helpful for everybody is, so I think you already answered the question about an online business. That's great. One came through on customer list. I think you've addressed that. What about an employer in multiple states? A question was asked, which state prevails? And I think we've answered that, but feel free to.
Yeah, well, I mean, it's a great question. There's no clear-cut answer. Where's the employee located? I mean, generally, that's probably going to be the choice of law. Well, certainly it's going to be the easiest to enforce that type of a choice of law provision if the choice of law is where the employee actually works. But, let's say, they work in various states, or let's say they work in Arizona, but they're based in Texas. And let's say there's a Texas choice of law provision. I mean, this depends upon your jurisdiction, and let's say that employee who works in Arizona, they still go for training sessions and for various other purposes to Texas quite a bit. There's a good chance that Texas law might be enforceable in that situation. It's not just, we're not just picking Texas law because that's where the company was maybe headquartered or based. I mean, this employee does have communications, whether on the phone and otherwise, with people from Texas, visits there several occasions. So, it doesn't have to be where the employee is, but that's probably the safest bet.
Okay. And I think, the next question is, what suggestions do you have to update non-compete agreements when there is no consideration other than an annual pay increase? That's a great question. I think, as we stated earlier, you can tie it to just about anything, a bonus, anything beneficial to the employee, although you want to make sure it's legitimate consideration. You don't want the court to challenge giving the employee $1 in exchange for this very broad non-compete.
Yeah, and usually, pay increase, that's absolutely going to be sufficient consideration in most jurisdictions. I guess I would just be curious if, what the circumstances were of that annual pay increase. Is that automatic? Did they have a contract that said they're going to get X percentage raise every year? I mean, if so, then there's not really any additional consideration being provided there. Right. So that might not be sufficient. But in normal circumstances, a pay increase absolutely would. And as Nicole mentioned too, in her presentation, it doesn't have to be a lot. And frankly, what about a bonus? You know, $500 bonus, that might be sufficient. And even there might be other non-monetary things that Nicole mentioned in some jurisdictions. Even the access to confidential information might be appropriate. You know, they might have already had access to some confidential information, but you say, okay, you know what, now we're going to let you see the big stuff, the trade secrets. But before we do that, you're going to have to agree to non-compete. I mean, that's going to be sufficient in most jurisdictions as well.
Okay, and what do you think, Eric, about, and I think we talked about this before, but what do you think about antitrust laws and that interplay with, you know, I don't know if it's really, the question is anti-piracy agreements, but I think it's more like the hands-off, you know, the employers agreeing to leave former employees alone and blacklisting. What do you think about that?
I mean, that gets tricky. I mean, right. You got to look at the specific state laws. I mean, and there's potential maybe antitrust laws that could come into play there. I mean, in general, at least in some of the jurisdictions where I practice, you know, you won't be able to identify specific employee. Like, you can't say, okay, I know you've got this department. We agree we're not going to solicit or hire any of those particular employees. You know, even if we don't solicit, they come to us first. You know, we'll agree not to do that. You know, I'd want to know what the state law says, you know, before agreeing to do something like that. I mean, it is appropriate under certain circumstances. You know, you've been subject to a corporate raid, they've stolen all your employees, and you come to an agreement that says, hey, all right, stop the bleeding, stop going after our people. Typically, what it might be able to get them to agree, you know, that they're not going to solicit them. I mean, that's usually the safest bet, is say, okay, well, you know, we won't solicit, or you agree not to solicit our employees. I mean, that sometimes is the best you can get. But if you want to take it to the next level and say, okay, well, you agree, even if they come to you, you know, unsolicited, and they want to work for you, you're not going to hire them. Yeah, that makes me a little more uncomfortable. And that's what I would want to focus or do some research on, that particular jurisdiction.
Thank you, Eric. The only other question I see is the intersect of severance agreements and restrictive covenants.
Yeah. And well, yeah. Well, and what's the question? Or
basically, can you essentially do restrictive covenants in conjunction with a severance?
I mean, absolutely.
Right.
In most circumstances. I mean, I suppose you could have a situation where, let's say the employee had already agreed in their employment agreement to a particular severance agreement. And here's the form of the agreement, the severance agreement, that they said, okay, well, if I leave under whatever provision of the employment agreement, I agree to execute the severance agreement. If that severance agreement did not contain a non-compete at that time, mm-hmm. I mean, there might be consideration problems because, right. You know, they could say, no, I'm entitled to, you know, sign that severance agreement that you offered me much earlier. So no, I don't have to sign that non-compete agreement. But if you weren't planning on offering that person severance, yeah, but absolutely, it could certainly be consideration, or you could add on a non-compete. And, you know, I have numerous companies who do that.
Right, right. So it seems to come all back to that consideration issue and whether it's going to be generally a forcible contract.
Yeah.
Well, that's, you know, I see other questions. They seem to be very specific. So please, if you have a question that we did not answer, please do email us. We'll be happy to respond in the best way we can. And we really do thank you all for participating today.
All right. Thank you.
Thank you.